Hey everybody, this is Tracy here with another edition of A View from Tracy's Point, and we are here to talk about a motion that was filed by I'll probably be saying this man, Vladimir Glazmir, who is an attorney for Darrell McDavid, and it is a motion to dismiss the indictment for pre-indictment delay, where he's basically saying that the government could have brought this case against Darrell McDavid years and years ago, and he is concerned that they cannot put on a proper defense because some of their key witnesses who could have discredited the government have been called home by the Lord. And it is important to note that although he has not given a ruling, Judge Lennon Weber did speak on this at the beginning of jury selection today, and he defers the ruling on McDavid's motion, alleging that prosecutors waited too long to bring charges. But he also noted, which is kind of giving you a hint of which way he is leaning, he noted that attorneys for McDavid probably waited too long also to bring this motion, because the pretrial motions have a deadline that the judge sets where he says all motions must be filed by this date, and that date has passed. I believe it was last week sometime, but these attorneys are still filing these motions as this stuff comes about. So anyway, hold on a second and I'll be right back to read the motion to you guys. Okay, it says, comes now defendant Darrell McDavid by and through his undersigned attorneys, Bo B. Brinley and Vadim, I always put that L in there, Vadim A. Glossman, and pursuant to Federal Rules of Criminal Procedures 12 and 48 and the Due Process Clause of the Fifth Amendment of the United States Constitution, respectfully moves the Honorable Court to dismiss the indictment due to pre-indictment delay. In support, the following is offered. 1. The introduction. The government has stretched this case well beyond reasonable limits while attempting to bring an indictment against Mr. McDavid. It tries to criminalize events that allegedly occurred decades in the past, but in the years since these events purportedly occurred, vital pieces of evidence have been lost or destroyed. Key witnesses that would have aided Mr. McDavid's defense have died. Worse, the government knew about these very same allegations when they allegedly occurred 20 years ago, and physically possessed some of the evidence that is now lost to time. Yet it repeatedly declined to bring any charges for years and waited until the 11th hour to bring a case after substantial pieces of evidence were already lost. As a result, Mr. McDavid is deprived of his constitutional right to prepare a complete defense and his right to a fair trial. As the law says, justice delayed is justice denied. That legal maxim is in full force here. The indictment must be dismissed because of inexcusable and unnecessary pre-indictment delay. Now, after reading this, I think one argument they would have if the judge does say that they waited too long to file this is that they can say, well, we did file motions to have these charges dismissed. We filed motions to have, some of the evidence thrown out and to get more information from the government, regarding the evidence and the chain of commands. But you didn't rule on those motions until yesterday. So you caused the delay. And so now that you have filed your ruling denying us the opportunity to get additional evidence, we should be allowed to enter this motion saying that this whole thing needs to be thrown out because of the delays. So that's one argument. And then once again, I have to give you guys this disclaimer that when I was earning my college degree, it was not in law. Okay, so I am just, from a layman's point of view, this is how I'm viewing how this should go. So 2, legal standard. While the statute of limitations provides the primary safeguard against overly stale charges, it is not the only constitutional protection to a prompt trial and administration of justice. United States versus Marion, which was a case heard in 1971. See also United States versus Henderson, which was heard by the 7th Circuit in 2003. And see also United States versus Sabbath, which was a case heard in the Northern District of Illinois in 1998, explaining that the statute of limitations does not fully define defendants' pre-indictment rights. Indeed, the Due Process Clause forbids pre-indictment delays and requires dismissal of the indictment when the indictment delay caused substantial prejudice to the defendant's right to a fair trial. And that's from Marion. And they're also citing United States versus Spears, which is heard in the 7th Circuit in 1998, stating that the Due Process Clause assures that the government does not subject a defendant to an oppressive delay. In fact, the right to a prompt and fair justice even predates the Magna Carta and is deeply ingrained in our criminal justice system because it is well-established fact that a trial conducted years after the alleged commission of an offense inevitably suffers from impaired fact-finding. And that was from Sabbath, and it was a supplement to the case. So this court must employ a 2-step balancing test to determine if the pre-indictment delay violated Mr. McDavid's due process rights. And then they say they're citing United States versus SOA, 7th Circuit 1994, United States versus McMacheri, 7th Circuit 2000. First, the defendant must show that the pre-prosecutorial delay caused actual and substantial prejudice to the defendant's right to a fair trial. And then Henderson, I guess, which was a judge who ruled on a case. The defendant must show actual and substantial prejudice, not mere speculation. And then McMacheri, and then they're stating where the comment is at. After this, the burden shifts to the government to come forward and provide reasons for the delay. So, and then that was one of the cases I quoted above. This court then balances the government's reasons against the prejudice suffered by the defendant to determine if the delay violated due process. And then that was a ruling by Justice Henderson. And the government does not have to act intentionally or in bad faith for this court to find a due process violation. If the prejudice to Mr. McDavid's right to a fair trial outweighs the government's reasons, it does not matter that the government acted intentionally, recklessly, or even negligently. See also United States versus Williams from the 7th Circuit 1984, explaining that the government's unintentional delay may still require dismissing the indictment if the delay is so detrimental to the defendant's case as to be patently unfair. And then from Sabbath again, explaining that the core holding of SOA is that pre-indictment delay is determined by a balancing test, not a rigid set of fault. United States versus Lavasco in 1977, noting that the government conceded that a prosecutorial delay incurred in reckless disregard of the circumstances known to the prosecution would violate due process. United States versus Ross, 9th Circuit, 1997. Oh my God. Allowing indictment delays based on negligent prosecutorial acts. Howell versus Barker from the 4th Circuit in 1990, allowing the same. So finally, and basically they're showing all the precedents that has been set for what they are about to ask the judge to do. So finally, a defendant may establish the prejudice caused by the pre-indictment delay both before and during the trial. See Federal Rules of Criminal Procedures 12B3A2, allowing pretrial motions to dismiss for pre-indictment delay. Marion, stating that events at trial may demonstrate actual prejudice of pre-indictment delay. For example, in United States versus Glist, the district court took pretrial motions to dismiss for pre-indictment delay under advisement and ultimately terminated the trial once the prejudice became apparent. And that was from 10th Circuit 1979. In addition, Rule 48 allows this court to dismiss an indictment if an unnecessary delay occurs. In presenting the case to the grand jury or bringing a defendant to trial, Federal Rules of Criminal Procedures 48B, while the Rule 48 standard is not circumscribed by the Sixth Amendment right to a speedy trial, it is driven by the same general considerations. United States versus Ward, 7th Circuit, 2002. So, 3, the argument. The government's delay in prosecuting this case is inexcusable. It has consistently stretched and twisted its allegations to try and bring a case against Mr. McDavid. In particular, the government has bent over backward trying to allege a factual basis for the obstruction of justice conspiracy, the centerpiece of their indictment. That was not barred by the statute of limitations. And then there's a note at the bottom that says Mr. McDavid still contends, as explained in his previous motions, that the charged conspiracy is barred by the statute of limitations, but he will not rehash those arguments here. Still, even under the government's theory, it only managed to obtain the indictment with a handful of months remaining on the clock. Nevertheless, the heart of the government's case concerns allegations that occurred decades ago. At its core, Count 5 alleges a conspiracy to create false documents and records in a DFCS investigation, and that's what Department of Family and Children's Services investigation occurring in 2000, and a Cook County grand jury occurring in 2002. Over 20 years prior to, let me stop there. So I'm thinking in one of the motions that I still have not presented to y'all, I'm so behind. They are going to bring up the fact that Rishona's parents were investigated by DFCS when the video became apparent. You know, when everything kicked off back in 2000, they were investigated. And I'm assuming that the government didn't find anything wrong, okay, and so they dismissed whatever allegations. But anyway, I believe that's what's going to be in those documents because that has surfaced in the past week or so. So the most recent document was allegedly created in 2007, over 15 years ago. See also Doggett versus United States, which was heard in 1992, explaining that the prejudice presumed from a pretrial delay intensifies over time. And over the years, evidence in the government's possession has apparently been lost. Witnesses who would have offered testimony supporting Mr. McDavid's defense have died. The witnesses who will testify undoubtedly will have faded memory of these long past events. See Barker versus Wingo, 1972, explaining there is prejudice when witnesses can no longer accurately recall events of the distant past, and this loss of memory is not always reflected in the record because what has been forgotten can rarely be shown. As a result, Mr. McDavid has been stripped of using vital pieces of evidence and witnesses, leaving him with inadequate alternate means of preparing his defense. This cannot and should not be the case. And then there's a note at the bottom that says, notably, 4 of the false documents and records were allegedly made even before the underlying obstruction offenses. was even enacted. So I guess they're talking about one of these cases that they are quoting. It says the Supreme Court has long held that a defendant is prejudiced by an excessive and unnecessary pre-indictment delay when he suffers the loss of evidence from death or disappearance of witnesses, destruction of documents, or failure of memory. Marion, 404 U.S. at 34. So they're citing a justice here. And this is precisely what Mr. McDavid suffers from here. Over time, the government has apparently lost the original version of Video 1, which is essential to Count 5. Mr. McDavid needs that actual video to point out the things on it that were shown to him before the 2008 trial. Things which shaped his knowledge and his beliefs regarding the 2008 trial and 2002 grand jury on which the obstruction of justice charge focuses. Further, there were defense documents and evidence held by Mr. Kelly's attorneys from the prior state proceedings that have been destroyed in the years after his case ended. Once the 7 years mandated for keeping files and records passed, documents critical to Mr. McDavid's defense were destroyed. These were documents establishing his relationship to the attorneys on whom he relied on for his beliefs and knowledge about the case. These documents include documentation regarding the obtainment of videos that the government now tries to falsely blame on Mr. McDavid. Not only this, but numerous witnesses have died in the years in between the events giving rise to the charges and the trial in this case. See United States versus Barkett, 8th Circuit, 1976, finding actual prejudice when multiple key witnesses died during a 4-year pre-indictment delay. One of the most critical witnesses who will undoubtedly be mentioned throughout the trial was Jack Palladino, an investigator. Palladino was present for critical events in this case. He was present for the obtainment of a videotape that the government now falsely claims was received by Mr. McDavid. Palladino should have established that Mr. McDavid received no tape, that he was not present when the tape was handed over, but because of the decades of delay, Palladino has died before this case was brought. Had he been brought in even a remotely timely manner, he would have been alive and able to testify. And you guys know they want to use written statements and I guess video from when they interrogated or questioned this particular individual in the case. That was part of the, I think the Santiago proffer is where they can bring in testimony from people and the people don't have to be there to testify or be questioned about statements that they made to get clarification and that type of thing. So despite the government's claims and prior motions, the original version of Video 1 is essential to the obstruction conspiracy charged in Count 5. As previously explained in prior motions, the charged false documents and records were created in response to the original version of Video 1 that the witnesses were shown in the 2002 grand jury. It is only the original version that matters here, for the jury to determine whether the defendants truly believed whatever videos they were allegedly shown had minors in them or not, which is critical to any evaluation of whether they obstructed justice. That must be shown the same version of the video that the witnesses and defendants could have viewed back in 2002. Only then can they fairly and accurately evaluate the reasonableness of the defendant's beliefs about what that video contained. Likewise, the original videos Kelly's defense team used in the prior state proceedings to create reports analyzing the videos and suggesting that they could have been altered are also lost and destroyed. Those items on which Mr. McDavid based his knowledge and beliefs about the video recording at question in the 2002 case are essential to his defense. But after Kelly's case ended in acquittal, the records were destroyed after the mandated 7-year retention period. These documents, too, would support Mr. McDavid's defense and help prove that he did not act with the requisite intent. See Glist, which was, I guess, a justice statement affirming finding of actual prejudice based on lost documents and investigative files being scattered among many people and offices. However, they are lost due to time and delay that was by no means necessary. And then let's go back up here because there was a very long note at the bottom of the previous page that says, as this court is aware, video 1 has been the subject of one of Mr. McDavid's previous motions where he sought to compel discovery to establish the chain of custody of the video and alternatively sought to bar the video due to a lack of authentication. Mr. McDavid understands this court's ruling on the motions. He still contends and will further establish at trial, however, that the original version is the only version of video 1 that can be shown at a trial, and that the government still cannot properly authenticate whatever version they currently plan to show. So this is going to get real interesting when it comes time for them to show that video, because they're going to be jumping up saying, "Object, Your Honor, that is not the video from 2002 grand jury or the 2008 case." And then I guess that kind of makes sense why they're trying to, or allegedly, I haven't read yet in any of the documents, but allegedly Michael Avenatti is supposed to be testifying, and then it would make sense because the videos that they are trying to enter into this case are the video, could be, I'm not saying it is because I haven't read it yet in any of these documents, could be the videos that Michael Avenatti brought up, took to CNN and showed them before turning over, in the secret meeting at the airport with Kim Fox over in Chicago at O'Hare. They was meeting in secret rooms away from everybody else, so nobody knew what they were up to. That those are the videos that they are trying to present in this trial. So it is going to get interesting. So Palladino, the defense's investigator, would have also offered testimony to reinforce what these documents show, impacting the jury's determination of Mr. McDavid's intent. He was hired to investigate the allegations against Kelly and was present for crucial events that would be hotly contested at this trial. For example, an essential component of the government's case involves an alleged contract to receive a tape by individual B. Palladino was allegedly acting as an agent for Kelly and Mr. McDavid. His testimony would have contradicted what this individual had to say, who was a government cooperator, and a large portion of the case would have hinged on what he said. SOA affirming finding that the defendant suffered actual prejudice because he could not recall the events of the offense after the pre-indictment delay. At the same time, this predicament was entirely avoidable. The federal government was in actual possession of the original version of video 1 when it first surfaced in the early 2000s. Both Chicago Police Department and FBI reports clearly state that FBI agents viewed and were sent the original VHS tape that contains video 1. And then it says C Exhibit 7/11/2002 FBI ROI 6/7/2002 CPD ROI. In fact, at the 2008 trial, a state witness testified that the original VHS tape was sent to FBI agent George Skaluba to analyze, and he had sent them back to the state investigators and possibly initialed the tape to confirm the chain of custody. See People versus Kelly, transcripts, and you guys know that was the 2008 case. The testimony also suggests that Skaluda indicated in his report that he could not identify Kelly. Yet now the government contends that they have no way to tell what video that was or if it even exists. Moreover, the indictment alleges that there was another agreement to retrieve a tape that involved individual C and individual D. The government was also aware of this allegation for a decade. Investigators interviewed individual D, which we know individual D is Lisa Van Allen, about the allegation back in early 2008 when she made similar accusations to those alleged in the indictment. Despite possessing the tape and having known about the allegations for decades, the government declined to bring charges. Indeed, it declined to do so on multiple occasions. See 10/3/2005 FBI ROI closing the Kelly investigation. 5/31/2018 FBI ROI closing the case file on new accusations against Kelly. Instead, it did not, while being fully aware of the allegations and possessing evidence for decades. As a result, they let substantial pieces of evidence get lost to time. And I think in the opening I said 2015. I was confusing that with the 5/31/2018 date and then also the 2005 date. So even according to their allegations, nothing has changed. They are the same allegations as they were before, but now Mr. McDavid has been deprived of significant evidence he needed to prepare his defense. The prejudice he suffers from due to this predicament pre-indictment delay has deprived him of the right to a fair trial, and it outweighs whatever reason the government has for such an unnecessary and excessive delay. See Sabbath dismissing the indictment due to pre-indictment delay because, in spite of the prosecution's knowledge about the circumstances surrounding the investigation, ill-prepared reports, elderly and sick key witnesses, a case agent who passed away, faded memories of the government's own investigative agents, and missing physical evidence, the government consciously delayed seeking an indictment for mere 4 years. The indictment must be dismissed. Conclusion. Wherefore, defendant Darren McDavid respectfully moves this honorable court to dismiss the indictment and enter any other equitable relief it deems just under the circumstances. Respectfully, Bo Brindley and Vadim Glasman. So what do y'all think? That sounded like a pretty good motion to me, and it sounded like a good reason to toss out whatever that part of it. Because I thought McDavid was charged with like 3 different things in this indictment, but it seems like the only part of the indictment, did I read that correctly? The only part that they seem to be trying to get thrown out is only one. Let me go back up here. Let's see. Seemed like they were only trying to get one of the charges. Maybe they're talking about all of them. I thought I read somewhere where he named one charge specifically, but maybe he's trying to get all 3 of the charges tossed out, which would make sense, which would make more sense than just trying to get one of the charges tossed out. So let me go back to the argument and see, did he say it was one? Okay, maybe he's trying to get all 3, like I said, which would make a whole lot of sense than trying to just get one. Or maybe the one that he's trying to get tossed out is the one that carries the most significant time, and without that one charge, and then without that one charge, the other 2 charges wouldn't stand. But in any event, I thought this was a pretty good motion. I think it made sense. I understand why he filed it so late. He filed it late because the judge didn't respond to the previous motions until yesterday, where he basically denied them all. And so maybe the judge got to go back with his old self, 85 years old, still trying to make sense of the world. But he now has to go back, I guess, and talk to his law clerk and be like, okay, now what do I do here? Like, what is he saying here? and which way should I rule on this? And then the law clerk will go and research and see if he can find precedents where, where cases of similar circumstances, the judge didn't throw out the evidence or dismiss the charge, and then they can go back and forth from there. But we know, as I've told you guys time and time again, a lot of these motions are not for the current charge. They are for the appeal down the road, because they know that the government is railroading their client, and so they need to put all this stuff on the record and be ready to file that appeal as soon as the guilty verdict and the sentencing come down. So go ahead, leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.